Hello, folks. This is the lecture to substitute for our election day on November 6th. I hope you're having a great election day. I certainly hope you all voted. Anyway, what I want to do today is finish off what little bit I wanted to do with the presidency and get started on the judicial system. And so we'll go ahead from that. Now, for those of you who are here from the 8 a.m. section, welcome to your first low-tech, poorly narrated video version of the PowerPoints. I hope you'll find it useful. For the afternoon section, welcome back. Here we go again. Your hybrid day for Election Day. So we left off having talked about sort of the constitutional source of the president's power, and particularly focused on the military, the commander-in-chief component. We also talked about the president's role in signing or vetoing bills. And since I wasn't as clear in all three classes, I wanted to sort of emphasize that the president basically has multiple options. 1, he signs it. 2, he vetoes it, in which case the Congress has the option to try and override. It takes 2/3 in each house to override a presidential veto. 3rd, if Congress plops it on his desk, he hates it, but Congress is still in session, he can refuse to sign it in a meaningless protest, and it goes into law without his signature 10 days later. Or if they put it on his desk and then they go into recess, then if he refuses to sign it, doesn't veto it either, but refuses to sign it, it dies for lack of signature, his signature, and that is called a pocket veto. Okay, so moving on from there. We talked about the War Powers Act. Don't need to go there anymore. Along with the War Powers Act, that's the president handling the military. Along with the president's role as commander-in-chief, he also is clearly the primary actor in foreign relations. He oversees our diplomacy. He handles international relations. He negotiates treaties, all of those things. Now, for binding law, treaties, etc., he has to work with Congress. The Senate, rather, has to approve his treaties. When it comes to things like tariffs and visas and such, the president tends to have more authority there than in most other forms of law. And we've seen our current president exercise that authority, perhaps even more than most people would agree is appropriate. Some things he's done by executive order that are being challenged in the courts. Sometimes he gets away with it, sometimes he doesn't. But he is definitely primary in our international relations. Conducts all those international negotiations, sends ambassadors that represent the country. He nominates them, the Senate approves them, they represent the president. They have to be approved or confirmed by the Senate. He receives foreign ambassadors and is responsible for that. Now, most of that happens under his Secretary of State, who is the top ambassador, effectively. But the Secretary of State and all the ambassadors work for the president, negotiates treaties and all of that. The president must sign them, but then they must be approved by 2/3 vote in the Senate. Ratified is the term we use. The constitutional language is advice and consent. They have to consent with a 2/3 majority. Now, he is also the chief executive or executor of government authority. He is effectively the CEO, chief executive officer, who runs the government just like the CEO of a business would run the business. He implements the laws, he implements the policies, he implements the budget, he enforces the laws. All of those things. The president runs the government. Now, he manages the federal budget. He oversees enormous numbers of employees, all of the federal military, all of the law enforcement, the federal law enforcement officers, the IRS, all of the federal agencies, the Environmental Protection Agency, the Food and Drug Administration, the Centers for Disease Control, all of those are executive branch services or departments that are under the jurisdiction or under the responsibility of the president. It is the president, through those agencies, that is supposed to implement, put into effect legislation. Now, as that happens, legislation, okay, so quickly, levels of law. The highest supreme law in the United States is always the U.S. Constitution. Law that is passed by Congress and signed by the president, we call that legislation. Legislation. Legislation, though, needs to get put into more concrete, more detailed rule books. Those rule books and the details of how we put the law into practice gets written up in what we call code. Code. So those of you that are into computers, think coding. So it's the specific details of how you make it work. The coding, the code. We call it code, legal code. Legal code actually is the implementation of the law as translated from legislation into the detailed rules that happens in the bureaucracies. The bureaucracies do that, and they work for the president. The president directs them in how to implement or how to write the code. So President George W. Bush was wonderfully honest about that. He would sign a big piece of legislation that he didn't like very much, and he would issue a signing statement and say, I am signing this bill, and this is how I'm going to implement it, and then proceed to describe a method of enforcing or putting it into practice that was dramatically different from what Congress intended and from what the language exactly said. Okay, that was not unusual that he would actually implement the law in specific ways that were in line with what he wanted. What was unusual about him was that he'd actually tell us he was doing it. All presidents do that. For example, under the Obama administration, he directed the recoding of things that focused on heavier enforcement of environmental stuff. Where there was room for wiggle room, we got more aggressive about enforcing environmental laws, about preserving the environment. Where there were rules on health care, we got more aggressive about making sure that insurers did not exclude pre-existing conditions and all those sorts of things. In civil rights, we got more careful about making sure people were not suffering discrimination based on race or gender or sexual orientation. And President Trump is doing precisely the opposite. They're redoing code to some degree, trying to go in exactly the opposite direction that President Obama had gone. That, to some degree, is expected. It's what they do. So the details get written up in the bureaucracies, and the implementation happens in the bureaucracies, and the president oversees that. There's some degree of discretion. Now, Congress can look over their shoulder, and if they go too far, Congress then can challenge that through the courts, by modifying the legislation to get more precise, by threatening budgetary challenges or whatever. But the president has some latitude. Furthermore, he oversees the actual enforcement of the law. In no modern country anywhere in the world is every single violation of every single law rigidly punished every time. In no modern country do we absolutely, carefully, rigidly enforce every law all the time. In order to do that, a government would have to have a law enforcement officer on the scene everywhere, 24/7, so that they could catch and then prosecute every violation. None of us want to pay that much for law enforcement agencies, to have that many cops. None of us want to be watched that carefully. So, what we do is we have a much smaller law enforcement agency, whatever it is, and we set priorities. Which types of legal violations are we going to focus our energy in enforcing? We never go quite so far as to say, oh, we're not enforcing that law at all. But presidents, with their attorneys general, decide where to put the emphasis. What will we focus on enforcing? Some real examples. The George W. Bush administration focused heavily on enforcing drug law, specifically punishing marijuana users and sellers, even in states where it was legal. The Obama administration says that's not the best use of our resources. And they directed federal law enforcement, do not focus on that. They never said, we will never enforce it. He directed his law enforcement, do not focus on it. Put your energy elsewhere. They kept it within their tool bag, so if it was just a marijuana violation, they could prove to jail a major drug king. They'd go ahead and use that, but that wasn't the priority. Attorney General Sessions right now wants to reemphasize that. The president's a little less emphatic about it, but we're seeing some more of that. The Obama administration seriously emphasized civil rights violations. The Trump administration doesn't really see that as a problem. They're not very aggressively enforcing civil rights violations or enforcing civil rights law. These are priorities, and elections have consequences. Who we elect as president makes a big difference on which laws our federal law enforcement agencies will focus on enforcing. That's some latitude that they have. The president appoints an attorney general who answers to the president, has to be confirmed by the Senate, but they are intended to implement the president's priorities. They determine when to fight in court to defend laws if they are challenged as unconstitutional. The president and attorney general determine that. Okay. Law enforcement. Moving on. If we were in class, we'd probably have a quick discussion of this, and then I'd have you vote. But quick question, can the president pardon a person who has been charged with or convicted of a federal crime? I have multiple options here. Okay, given that you've lived through the first 2 years of the Trump administration, you totally know that the president can pardon someone. Does he have to give a reason? Does he have to have approval of Congress? Does he have to have the Supreme Court's approval? No, not at all. The answer is simply yes, he can. Now, he and some of his supporters say he can even pardon himself. That is not settled law at all. We don't know what would happen if he tried to pardon himself. If the courts did not recognize that pardon, which they might not, we would end up with a constitutional battle over that, and ultimately the Supreme Court would have to decide if he tried it. Who knows? It probably won't happen. But we don't know that. Now, that seems a little weird. We have a whole court system to determine guilt and innocence and a fixed punishment. We have guidance within the law as to how to do that. So why in the world would we have the president given that sort of authority. Well, this comes out of a lot of our traditions and a lot of our legal systems or our government systems are sort of borrowed from the British tradition. As much as we like to break ourselves away from Britain in the Revolutionary and early constitutional period, we still borrowed a lot of their ideas. And one of them was an idea that there are essentially two different sort of roles in the executive roles in a government. There is one that's called the head of state. This is sort of the symbolic and sort of royalish, sort of royal-like, at least, role of executive leadership, of leadership. And in the head of state, I like to call it the ribbon cutter in chief, right? The president does all sorts of ceremonial things. And that's a major function of the presidency. There's no superpower there or anything, but they do that. They have all sorts of ceremonial roles. Within that category, there's a long-standing British tradition that kings must ultimately approve of, especially death penalty cases, executions. But within that, there is this idea that even though you have a whole judicial system, the king ought to be able to intervene and grant some sort of mercy. Intervene on behalf of mercy or something. And so the kings have these kinds of power, or they did traditionally, and we have granted that by tradition and now in our Constitution to the president. So the president can grant pardons and reprieves. Whom can the president pardon? A person who's been convicted of a federal crime, a person who's been accused of a federal crime, conceivably a person who has not yet been accused of a federal crime. But he can. Does he have to give a reason? No, he doesn't have to. Does he have to go through a formal process? No, he doesn't have to. Now, in modern times, each of our presidents and our White House has an office, a formal body of lawyers that process and look at requests for pardons or reprieves. And they look at the case history, they go through the transcripts of the court, they look at all sorts of things, and they make a recommendation to the president. The president typically, if this body says don't pardon, the president typically does not. The president typically pardons fewer people than his pardon board recommends. Now, what can a president actually do? It fits into several categories. He can grant a pardon, which is we're wiping it clean and pretending like it never happened. He can grant clemency. This is reducing the sentence or the penalty for some reason of mercy. So a person's already served 5 years and they've got 10 more and they're dying of cancer. We'll just send you home so you can die with your family around you. Or whatever, for some reason of mercy. That's clemency. The conviction still stands. You're still a convicted criminal, but we're going to lift the penalty because we want to be humane. They can commute a sentence. Say, the sentence is just too severe. I'm going to shrink it. You're still guilty. There's still a penalty. I'm just shrinking it. Why? Because I want to. Because I think it's right. Not for some particular reason of mercy, but because. Now, anytime a president grants a pardon, clemency, or commutes a sentence, someone's going to be unhappy. Victims' rights groups, the people who were harmed by this person's crime. If, like President Trump, they are explicitly political pardons. I mean, Joe Arpaio, and a couple of the people he has pardoned already, these were absolutely all about sending political messages, not really so much about justice or his sense of justice. It was just political messages. And, that offends people. That upsets people. But whenever they grant a pardon, it tends to upset people. So typically, they don't grant pardons very often until their last few weeks of office, when they're sort of termed out. Now, when they do one of these things, it angers people and sometimes becomes scandalous. Some of the most infamous cases, after the Watergate scandal, after Spiro Agnew, the vice president, then Richard Nixon, the president, both resigned in disgrace because they were going to be impeached and removed from office, and they wanted to avoid that. One of the first things President Gerald Ford did as the newly sworn-in president was to pardon both Richard Nixon and Spiro Agnew. Now, many people were very unhappy about that because we never got to have the court cases and the hearings and all the stuff to find out, well, who else was doing it? What were the details, so that we knew enough, hopefully, maybe to learn from it, so that their conspirators, the people with them, would also be held responsible, all those sorts of things. Now, pardoning a former executive officer when he's charged with crimes, particularly severe crimes, is very normal in democracies. Democracies do this. And the reason democracies do this is because it's important in democracies that a president or prime minister, when his term is up or when he loses an election, he retires and goes away and hands over power. Now, if everyone knew that if your enemy got elected after you and then came after you and prosecuted you criminally and jailed you or executed you because, you were the political enemy, if that was a common thing, no one would ever give up power voluntarily. We would have civil war at the end of each term, or at each transition, or we'd have some sort of assassinations or whatever. So it is normal, if there is evidence of serious criminal behavior, that we have a trial. That in that trial, we see all the evidence. And then once we see all the evidence and there is a sentence passed and there is a verdict issued and a sentence passed, then their successors pardon them. And they never serve jail time. And the reason for that is not because powerful people shouldn't go to jail. It's because we do not want any hint that political successors, political rivals who win elections, would then use the courts to, well, as Mr. Trump likes to say, lock her up. When we use courts and jail to settle old political scores, then there is a really strong incentive for executives especially to hold on to power by cheating or by violence, if that's what it takes. So democracies do this. Now, why it was scandalous with Ford was because they did it without the trial. Now, another one, at the end of his second term in office, Bill Clinton pardoned a whole bunch of people who'd never gone through the process. Now, that's not illegal. It's legal. It's just unusual. Really unusual. And so, because he did it, and he did it on his very last day in office, that's when he issued those pardons, many people thought, there must be something going on here, and there were investigations, and many people saw that some of the people that were pardoned never asked for them. A few of them that were pardoned had asked for them, and the pardon board said, nah, not a good choice. And a president doesn't have to follow that, but they almost always do. And so there was this question, did Clinton sell pardons, or was there some political trade-off? And in the early investigation, it sort of looked like most of the people that got the special pardons, the surprise pardons, had donated money to causes that were important to the Clintons, particularly Hillary's election to Senate, or to the Clinton Library, or to the Clinton Global Initiative, and so there was a major investigation I mentioned that we had investigations into the Clinton administration forever, their entire term, his entire term. Well, we got a whole new investigation. The same special prosecutor got re-upped again to investigate him again. And, well, ultimately, there were no formal charges filed because he didn't find evidence. On the other hand, ultimately, there was a negotiated settlement. President Clinton agreed to surrender his membership in the Bar Association of the state of Arkansas. I won't be a lawyer anymore. And his certification as an attorney qualified to argue cases before the U.S. Supreme Court. In exchange for Prosecutor Ken Starr dropping the investigation completely and ending any sort of further investigation. So, did Mr. Clinton admit to guilt? No. Did Mr. Starr say he's not guilty? No. Did Mr. Clinton surrender something to make the thing go away? Yes. But how likely is it that a former president is going to continue practicing law as a regular lawyer? It's never happened. Was unlikely. He surrendered something symbolic. No money, no real power, something symbolic. If Mr. Starr had been able to prosecute, he'd been chasing Clinton for 8-9 years by this point. If he'd been able to make something stick, he certainly wouldn't give it away for nothing, for a symbolic gesture. So clearly he couldn't make a conviction stick. But on the other hand, the Clintons wanted it to go away. Okay, is settling when you're being sued or prosecuted? Settling when you give away something symbolic but nothing of value? Does that mean you're guilty? Do businesses frequently settle out of court and pay even hundreds of thousands of dollars sometimes just to make it go away? Even if they believe they could have defeated it in court? Because it will cost millions to defend yourself and win in court, but only a couple $100,000 to make it go away? Yeah, they do it all the time. Okay, so it left it kind of messy. There was another interesting case. It was more a governor's case, where the governor of Illinois some years back, Governor Ryan, not related to Paul Ryan, a different Ryan, well, I might have been related, I don't know, but anyway, who all of a sudden commuted all the sentences of every death penalty case in the entire state from death to life in prison. Now, he had been elected as a pro-death penalty governor, and he continued to argue that the death penalty was a good idea, but he commuted every single death penalty case in the state, all of them, from death to life in prison, reduced the sentence. Okay, why? Well, it turns out there was a major scandal in their crime lab. Their crime lab for at least 10 years had been in corrupt and illegal ways collaborating with police officers and generating false positive results on fingerprints and blood types and all those sorts of scientific tests. They were cooking the science, cooking the books, and generating false positives. And there had been, by that point, several death row inmates who had been proven to be not guilty. Had been their convictions had been thrown out when better evidence came out. And there had been several people from the crime lab and their state police department who'd been convicted and jailed for this corrupt cheating. Well, the governor's response was, I could not possibly sign a death warrant to have someone actually killed when I knew they were convicted by evidence that was quite possibly false. So he commuted all their sentences. Now, the voters of Illinois were not happy with him, and they threw him out in the next election cycle. So pardons and these kinds of things are often politically sensitive. Certainly, people's reactions to Mr. Trump's use of it so far have been controversial, or at least the responses have been the people felt odd about it. So continuing on, the president's sort of informal roles. These are things that are not actually in the Constitution per se, but things that are roles we expect of the president. The cheerleader-in-chief concept, of course, this is kind of tongue-in-cheek, but the idea here is the president pulls the nation together, tries to help us as a nation feel good about ourselves, feel good about what's good with the nation. In some cases, this can be really important. For example, in the time of a recession or a difficult time, giving Americans hope that things can move forward, can get better. Ronald Reagan was especially good at this. His "It's Morning in America" speech is famous for its effectiveness in convincing Americans that, no, this is not the end of America's greatness. So, an important role. Sometimes when they botch it, they end up looking really stupid, but whatever. Party leader, the president becomes the de facto leader of his or her party. People, all the time now are talking about how the Republicans have become the party of Trump. Well, yes, the political party of the president does take on that person's leadership role. Spokesman to the world. Because we're a presidential system, our president represents our people. The people, albeit indirectly through the Electoral College, the people pick the president. Therefore, when people see us, they think of us as our president. That's who we are. If our president looks weak, so do we. If our president looks aggressive and cruel, so do we. So it's an important role, informal, but it really is important. The president expresses our collective sense of sorrow or grief when an ally loses a leader, when a natural disaster happens in an allied country, or in any foreign country, when we have our own natural disasters or man-made disasters, such as mass shootings or whatever. The president sets the tone, brings us together. Historically, they have done a good job of trying to make us see our better side, help bring us together. Sometimes they politicize this. As you noticed in the news last week, there was serious criticism from some of President Trump's response to the shooting at the synagogue in Pittsburgh, when he said, would have been different if they'd have had an armed guard. Well, politicizing the thing. He's not the first or the only one to do that. But when they do, it sort of downplays their role. The national pastor is another tongue-in-cheek sort of thing. Most of our presidents do historically call on the nation to join in prayer or sending good thoughts in times of particular challenge. Of course, there is a separation of church and state, but the president still plays something of a spiritual role. Talking about what makes for strong presidents, there are lots of things about it. They have substantial constitutional powers, especially in foreign affairs and the military. The president is the one and only person who can say, the people of America elected me. Now, that is a relatively potent argument, depending on how the election went. In a case, as in with President Trump at present, or Bush in 2000, when more people voted for another candidate, it's a much weaker argument. But still, through our process, the argument being the nation, the whole nation elected me. Any other person is either elected by just a state or they're simply nominated. All of these people have incredible personal skills. None of them, even the most bland of them, would be ordinary in their interpersonal and personal magnetism skills. So that's something they can call on. All of them have the support of their own political party. Even as we saw more than half, almost 2/3 of the Republican Party in the primary process did not like President Trump. Once he became their party's president, their party is completely behind him, almost 100%. Virtually all of them come with extraordinarily supportive families. With President Trump, he brings in Ivanka and Jared as a major part of his political team. Typically, it's the First Lady that plays the biggest role there. Our First Ladies have been very influential in our history. They generally pick a campaign that they tend to support. Laura Bush's was education. Michelle Obama's was nutrition. Nancy Reagan was the war on drugs. Barbara Bush was, I don't remember what Barbara Bush's specific one was. She was sort of generally for women choosing what they wanted. She was herself openly pro-choice, while her husband, the president, and their party was pro-life. But at the same time, she was a traditional stay-home mom and grandma. And she felt strongly that women ought to be able to make those choices themselves. That was something important for her. And so on. So, presidents oversee the entire federal bureaucracy. That's millions of people that are their employees that are supposed to be implementing their rules. They do have a cabinet whom they appoint that oversees that bureaucracy. An interesting phenomenon there. Well, anyway, and all those are their people. We'll come back to that. Now, they also have sources that weaken them or check them. There's a constitutional balance. Presidents don't have a dime to spend without Congress giving it to them in the budget. Any presidential action can be reined in by a combination of Congress and the Supreme Court. They can do very little, honestly, with executive orders. Only modify the implementation of law. They can't create new law. They certainly can't amend the Constitution. All of them have personal weaknesses. We're all well aware of Mr. Trump's tendency to shoot off at the mouth, his tendency to be loose with facts, his sort of personal thin-skinned nature. But all of them have their weaknesses. President Obama was often considered too cold, too slow to respond, too professorial in the way he approached things. Some argued that he tried to use the president's power too aggressively. Some other interesting personal weaknesses. Obama himself was a smoker when he started running for office. And in their negotiations, Michelle wasn't keen on him running for presidency. In their family discussions, there were promises he made to his family, to the girls. It was they would get a dog, which they ultimately did. And to Michelle, he promised that if she would support him in the presidency, he would quit smoking. Interestingly, it took him a year to year and a half into his presidency before he achieved that. That was a rare case where the media collaborated with the president and his family. Neither Barack nor Michelle Obama wanted any kid to be able to point to the president and say, well, the president smokes, when their parents tell them they shouldn't use tobacco. So he went to great lengths to keep that low key, and they requested the media not to take pictures of or to show pictures of the president smoking, which the media largely did. Ultimately, it was about a year and a half into his presidency when Michelle went to, was on Oprah and told Oprah that he was finally tobacco free, which was kind of interesting. But they all have personal weaknesses. Bill Clinton was a womanizer, had a tendency to lie on occasion for political purposes. President Trump's tendency to lie kind of makes Clinton's look a little sort of understated, but they both had that in common. They were both womanizers. George Bush Sr. had too much of a tendency to rely on his vice president, as we're sort of seeing played out in the new movie about the vice president. He also had a tendency to make up words and say things that were kind of stupid sounding, although he sounded really well educated compared to what we hear today. But they each have their own personal weaknesses. Ronald Reagan, he was fabulous at picking really smart people to help and to administer underneath him, but he tended not to pay attention to what they did once he appointed them. So he was a little bit not very detail-oriented, and that was kind of a problem for him in his administration. All of them are limited in time. They only get 24 hours a day. They only get up to 8 years. That's assuming they get a second election. All of them also have, millions of employees. Now I put that in strengths before, but it's also a potential weakness. They don't directly supervise those employees. And those employees have sort of special protected status, the civil service protection, which is a lot like tenure for faculty. The idea, once a person has been there for a certain time and has gone past their probationary period, they cannot be fired without demonstrating cause. They have to be shown to be not doing their job or to be doing something inappropriate or illegal. They have to be proven to be incompetent. The reason for this is in their early administration, they would fire everybody and change again, and that led to serious incompetence in the new government every time. And it was a problem, so we came up with the Civil Service Act that requires special qualifications and then gives them protections. But because they have those protections, that means they can kind of drag their feet. Even the cabinet appointees will sometimes have a tendency to to go native, to do their job more aggressively than the president likes. The president is famously really unhappy with his attorney general because, well, among other things, his attorney general is actually doing the job in a way that is not what the president intended. That the president intended him to be the president's own personal attorney, to protect the president no matter what, and to enforce laws in ways that support the president. And he has tried, at least in some respects, to follow standard practices, including recusing himself from something where he had a vested interest, the Russia thing, because he's going to be part of one of the folks tainted by any sort of claim or proof that the president's administration collaborated with Russia, so he had to recuse himself. In other words, step aside, not work on that. That made the president really angry. Other presidents have had similar problems. Famously, George W. Bush appointed Christine Todd Whitman as his secretary of the EPA. And he picked her because she was this really accomplished governor of New Jersey. And she, like he, felt like environmental laws were way too aggressively enforced. And that was what he expected of her, was to minimize the enforcement, behave essentially the way our current leaders are doing, sort of actually, implement the laws in ways that basically make them gutless. But once Mrs. Whitman got in the office, she realized, gee, if there are major environmental disasters on my watch, it's my fault. And she was a very capable, competent administrator. And so suddenly she realized, oh, wow, these laws actually matter. And she tried to aggressively enforce them, which made the president unhappy, and he fired her. They tend to go native. The civil servants have the ability to resist by dragging their feet and all of that. That's what the Republicans these days call the deep state, as if it's some sort of conspiracy that cuts only one way. It doesn't. They certainly have an interest in maintaining the role of the civil service, but it's not either Republican or Democrat. It's more about maintaining the mission which is exactly what we hired them for. But in terms of the balance, presidents were intended to be definitely second to the Congress. We've seen a lot of change over time. They were to be strong in international affairs, but weaker than Congress in domestic affairs. Always to be constrained by the Constitution. Now, there are several other things that I had in this. I'm going to kind of skip through that. One last thing. I'd like to pitch a really fabulous book that I thoroughly enjoyed. There are lots of books on the roles of First Ladies. This particular one by Margaret Truman. Margaret Truman was the daughter of Harry and Bess Truman. And she wrote this really fabulous sort of tale of the political roles of first wives, first ladies, throughout history, up through Hillary Clinton. So it's a little dated now. The cool thing about her is she was actually a murder mystery novelist. So she writes like a novelist. It's really interesting. It's well written. Interesting to read. Something I'd recommend if you're interested in the roles of women in U.S. history or U.S. politics. The fascinating thing is we have women playing really important roles in politics at times when, well, that wasn't actually the norm. Or we didn't think of women playing those kinds of roles at the time. Okay, so we transition from there. That's all I had to say about the president. Transition from there to the judiciary, which is what we're supposed to be doing this week. Week 11, the judiciary. So 3 branches of government. We already talked about the constitutional structure. Article 1 is Congress. Article 2 is the president. Article 3 is the judiciary. Now, the U.S. judiciary is set up with 1 Supreme Court. The number of justices on the Supreme Court are determined by Congress. Initially, we started with 6. Over time, they expanded up to 9. These are acts of Congress. At one point, President Roosevelt proposed expanding it to 13 so that he could stack the court. This is Franklin Roosevelt. Congress did not go for that, even though they were of the same party as the president at the time. Initially, the Supreme Court justices rode circuit, which means they spent most of their time out being judges in the various states. We don't do that anymore, but we'll come back to the structure here in a little bit. I want to talk theory today and look at different models for how the judiciary is structured. But then here we go with the clicker questions that I would ask in class. First would be, how does a federal district judge get the job of federal district judge? We would do this in the clicker, and you'd have options. I probably will put something like this on your Canvas quiz that goes along with this lecture. We would have a question about what do we call, documents submitted to the Supreme Court from interest groups and others who are not parties to the case, but have a stake in the outcome. There's a term for that. It's in your textbook. These would be reading questions, really. How many justices on the U.S. Supreme Court when it has its full number? Okay, that's in your text. I even mentioned it already. Okay. Now, what I want to talk about really, though, is different ways of conceiving the role of a justice system, the role of judges. Historically, there are essentially 2 broad models. This is from legal studies. I think you'll see some parallels between this and some of what we did with Max Weber earlier, although they're very different realms. Okay. The one model is called the natural law or natural justice model. And I'll alternate between using those terms natural law or natural justice. The other one is the legal rules model, or the law-based model, or code, perhaps. But anyway, natural justice or natural law versus legal rules. Now, in the natural law model, the basic premise is what we really want out of law is to find that just right law. Somewhere out there is a natural order of law that any clear-thinking, right-thinking person could simply come up with. In one version of it, they come up with it because they're smart. In another version of it, it is simply given by God. It's revealed law. And it is what it is, and it's absolute. and it's relatively unchanging. That's the natural law model. In the legal rules model, the idea is there isn't any necessarily discernible natural law that we could all agree on. If there is such a thing, we don't know what it is. So we derive laws out of the social contract, or out of the imposition of good, hopefully good, of legislators, of government, some authority figure that imposes it. But the laws are written, and there are clear, discernible processes and rules that we apply, and we implement those rules. And we can change those rules over time through our social contract, however we do it, through our legislative process. So those are basically the two models, and I want to kind of look at how those two work. You're looking at some basic outline of what we're looking at, outline of the core elements of it. So here in this funny little chart, the idea here is in this small thing on the left, we have different characteristics. The source or standard, where does the law come from? The locus of supremacy, who ultimately decides what the law is or how to apply it? The ideal judge, what constitutes a good judge, the ideal type of what a judge ought to be. What is the goal or intention of their decision-making processes? What are they trying to do? What are its weaknesses and what are its strengths? So, in the natural justice model, the theory is, or the idea is, the source or standard of law is, well, it simply exists out there somewhere, but ultimately, how do we determine that? Community standards. The community has its set of moral values, what is right and what is wrong, and that's what is the standard of the law, a general sense of right and wrong, decided or established by community standards that we hold as sort of common sense. Okay, well, ultimately, who decides exactly what that is or how to implement it? Whoever we appoint as judges, they are the final deciders. The decision makers, they decide it. In this scenario, an ideal judge is considered someone who is experienced, who is wise, someone who can understand the intentions of the law and implement it with wisdom and insight. Generally, they're perceived as someone sort of mature, experienced. When they implement justice or judgment, their goal, what they're trying to accomplish, is real justice. Something that we could look at and go, yes, that's fair. Yes, that's right. Or establishing policy that is wise, that is good for the community. And so the judges themselves, because there isn't necessarily a core, clearly defined written law, the judges themselves are defining the law or as we go. And what we want is good law, good policy, good decisions. Now, if you give judges that much latitude, then your vulnerabilities, your weaknesses, your problems with the system would be judicial malpractice. What if the judge really is not that wise? What if the judge really is not that insightful? Judicial malpractice. What if the judge is a bigot? What if the judge has his or her own biases? Maybe they're all men judges and they assume that women are unreliable. Maybe they're all old judges and they assume that young people are untrustworthy. They have their biases. Maybe they're all of one race and they assume people of other races are somehow either lesser or not trustworthy. Another problem would be consistency, or rather inconsistency. If you get a different judge, different judges might interpret things differently, might apply things completely differently, might have a whole different set of ideas. So which judge you get makes a great deal of difference. Even the same judge on different days, without clear rules. Right, on one day, everything's good, life is happy, the judge is feeling optimistic, so you get a friendly, optimistic kind of approach. On another day, he may be feeling grumpy. He had a fight with his wife or his son or his daughter or something, and life is awful, and he's really angry, and, well, then you get that version. Typically, in these kinds of systems, you end up with inconsistency. Now, another typical problem in these kinds of systems, because they are experienced, wise, that translates into old, they tend not to be super adaptable. Old people have wisdom, They can draw on past experiences, but they often are less adaptable to a changing world. And so your law might not respond well or might not adapt well to changing circumstances. And even if principles stay the same, circumstances change, and maybe the application of law might need to adapt along with that. So unresponsiveness or rigidity can be serious problems. Rigidity being, it is what it is, right? No adaptation. It is what I think it is anyway. Now, potential problems. Potential strengths. A judge could be really flexible. You have the general principle, but then you make the punishment or the decision really fit the actual circumstances of the case. You can be adaptable. I mean, theft of $50 worth of goods is not necessarily always the same. Each theft of $50 worth of goods is not equal. Possibly, depending on motive, depending on history, depending on patterns. If it involved violence, if it involved threats to people, if it was just property, all of those things may matter. A hypothetical from literature. In the famous Victor Hugo novel, Les Miserables, or Les Mis, as it became in the musical version of it, we have a young man trying to help his sister feed her children. So a young man trying to help feed his nieces and nephews. And times are hard and he can't find work and there's not enough food. And he breaks a window pane and steals bread from a bakery to feed his starving nieces and nephews. It's not even food for himself. It's food for children that are not even his children, but his nieces and nephews. And that gets treated as if it were a, well, he gets sentenced to many, many, many years. Ultimately, he spends 19 years in prison over that. Now, clearly, breaking into a house and breaking into someone else's home or business, a bakery was in a home, in this case, so breaking into someone else's home and stealing real goods is a serious problem, no matter what the motive. But there probably is a difference. We could probably all agree that there is a difference between someone literally trying to prevent children from starving, stealing, to prevent children from starving, versus someone who has made a choice to make theft his or her general means of living, and they're stealing instead of work, or they're stealing to increase, just to enjoy, fine jewelry, or to enjoy something that is not a necessity. Those are different. A first-time offense might be different than someone who has done it many times, and we may want to be adaptable to that. Okay, flexibility is possible. We can get justice served because the goal of the decision is good, wise, fair, just decisions. So you can get a situation where if your judges are wise, implement it with wisdom and good understanding, you can get really good outcomes. That's the natural model. Now, in this scenario, I want to talk a little bit about the ideal judge. What does an ideal judge look like? And here again, from literature, we have this wonderful story that kind of typifies the idea of a truly wise judge. This is the famous King Solomon in the Bible, in the Old Testament. Now, Solomon is the son of King David, who reunifies who unifies and becomes the great king of the Hebrew nation. And his son Solomon ascends the throne as a very young man. And in the biblical story, Solomon behaves in a way that pleases God. And God offers Solomon a gift. Solomon, you've pleased me. What gift would you like? What can I give you? And Solomon asks for an understanding heart that he could judge the people wisely. And God says, granted, you are wise. In fact, you're so wise, you'll be talked about forever, and there will never be anyone as wise as you. Okay. Solomon the Wise, that's what he's often referred to. Now, shortly after this event, when Solomon is told by God that he is granted wisdom, he faces a custody battle. Really not a custody battle, it's a maternity battle. As the story goes, there are two women in a household. Each has a son at about the same time. They are probably servants in the household. It specifies that no one was with the women when they had their sons. So we don't have witnesses that saw the babies born. Shortly after the babies are born, one of the babies dies suddenly in the night. The story says the woman lying with her baby smothers it. She rolls over and the baby suffocates. It's probably a SIDS death. Something horrible. But anyway, the woman whose baby dies wakes up and realizes her baby is dead. And in the night, she quickly switches babies. And in the morning, the woman whose baby had not died wakes up and finds the dead baby in her bed. She's horrified, but then she realizes this is not my baby. And they end up going through their judicial system with each woman claiming it's my baby and the other saying no, it's mine. Now they get before the king, Solomon, who is the Supreme Court of the time, and each of the women present to Solomon their story. The baby is mine. Her baby died and she switched. Now think about that sort of case today. Two women, each claiming the baby is mine. Now we would use DNA testing and figure out, well, what do the genetics say? Solomon didn't have that option. We could go to other people who knew the babies. It says that no one was with these two women. Presumably other people had seen the babies. Maybe he could sought out witnesses. He doesn't do that. Solomon's solution. Some of you will know it already, but Solomon's solution is to declare, we can't tell. There's no way to know which baby it is. Guards, bring a sword, cut the baby in half, and give each woman half. Okay, that sounds really crazy. Of course it is. But out of this scenario, one of the women, another rendition of the thing, one of the women's response is, okay, king, you've spoken. That's justice. If you can't decide, yeah, I guess that works, right? Whatever you say, king. The other woman, by the way, the one that says that is the woman who currently has custody, currently is, brought the baby in. She's the one who isn't the biological mother. The other one, her response is, no, anything but that. Don't kill the baby. Don't hurt the baby. I lied. It's not my baby. The dead one's mine. I was just trying to steal her baby. Give her the baby. Just don't hurt the baby. And Solomon's response is, now I know which is the true mother. Now that one seems a little weird. What mother, what woman who wants a baby bad enough to steal it is going to be happy with a system of justice that says, as long as she doesn't have a baby, it's okay. Go ahead and kill the baby. I'm fine with that. No woman who wants a baby is ever going to behave that way. No person is ever going to behave that way unless you know it a little deeper. Okay, so they're under the 10 commandments that Moses had given. One of those great commandments was, thou shalt not bear false witness, which is, don't perjure yourself. And that was specifically in a judicial system. Both of these women were under oath. And what happens is the penalty, by the way, for lying under oath is stoning, death by stoning. So what we have going on here is both of these women have sworn that it's her baby in front of the king. They've taken an oath in front of the Supreme Court judge. And now the one woman says, never mind, I lied under oath. Don't kill the baby. But she's right there admitting in front of the Supreme Court that she perjured herself. So what she's literally saying is, Kill me, don't kill the baby. Kill me instead. Now, do real mothers sacrifice their own lives for their children? Yeah, all the time, right? You know that. But does a wannabe, but it isn't actually her baby yet, is she willing to go, I lied. Never mind, don't kill the baby. And if that means you kill me, so be it. That's much less likely. So, what we have here is this wise judge. This is a story, right? You can take it literally or not. I don't really care. It doesn't matter for our purposes. This is a story setting up what the ideal wise judge is. Is that what we want of our judges in modern America? Forget the evidence. I understand human nature. I'll put them to the test. Not so much, right? Not so much. So we don't want that kind of wisdom necessarily. It would be nice maybe, but no. We want evidence. Okay, so that's the natural law model. We'll come back. Well, we'll look at the good judge in the legal rules system here in a second. Okay, so the legal rules system. Again, the characteristics here, the source or the standard of the law we're applying is the law texts. The law is written. Where is it written? You know, for us, that's our legislation passed by Congress and the codes interpreted. The law, it's written. So we use the law texts. The supremacy, or who's the ultimate authority on that? Well, whoever the lawmakers are, specifically the people in a modern context, through our elected representatives, through Congress, right? We the people set up the law. That's that's where it is set. Our ideal judge is not Solomon. Our ideal judge is a legal craftsman, someone who knows the law, knows the processes for interpreting and applying it, and is skilled at finding the appropriate legal passage and knowing how to interpret and apply it. The goal of the judge is not to somehow or other, by inspiration or magic or incredible personal wisdom, find justice. No, the goal of the judge is to apply the law equally, consistently, treating all the same before the law. Judges don't make law, judges apply it. Judges make decisions based on the rules they are given. They are not lawmakers. So, or they are not policymakers. They're not finding justice somehow. They're following the rules set up in the law. So, treat everyone equally, be consistent, follow the law. That's the goal. Now, in this kind of system, what if you have stupid laws? That would be legislative malpractice, right? The lawmakers make stupid laws. And we can certainly look at all sorts of different ways where we have laws that we see laws that we might think are stupid. An area I find frustrating, I think a lot of people do, is we have laws that define what is a felony, what is a misdemeanor. We treat them differently based on the level. Well, from the 80s, we came up with these odd laws when we were really paranoid about drugs, and we now have felony level laws for possession of or use of drugs that we may very well want to ban. I'm not a fan of legalized marijuana myself. I think it's I do think it does a lot more harm than people like to argue. But is someone smoking a joint the same level as someone who literally does another person physical harm by violence? A physical violent assault? No, not even close. But yet our law treats them as equally. You can have a violent offense and still get a job in the public sector, still get financial aid, become a school teacher even, as long as it wasn't violence against children. But if you have a drug conviction, no. To me, that's silliness. That's legislative. That's stupid law. We have laws about sexual assault or rape, and we punish them quite severely, and we make a person convicted of those kinds of crimes register for life as someone with a pattern of this kind of behavior. the sex abuser registry. And that's good. We also within that have there are good reasons for that. We have a law about the age of consent, right? In California, a person can't consent to sexual interaction until they're 18. And we have laws that define a person, an adult, who engages in sexual behavior with a child. We define that as statutory rape. That's rape, and a person engaged in statutory rape can be convicted and can be sentenced to serious time and be forced to register as a sex offender for life. Well, when you're talking about an adult, like someone 30-ish or more, and a child, someone 14 or less, that's serious, right? That's a form of that's definitely child abuse. We're talking about something really egregious, and that ought to be treated that way. On the other hand, the way we define it, a sexual interaction between a couple of teenagers, one of whom is 18 in a day, the other one of whom is 17 in 364 days, right? They're only 2 days apart. But technically, a sexual interaction between those two would qualify as statutory rape. And the older of the two, by just a couple of days, could potentially be branded a felon and have to register as a sex criminal for the rest of their lives, even if the interaction was, in both of their minds, something that they were something they both consented to, both wanted. Now, in no way are the two examples, right? A 30-year-old and a 14-year-old engaged in a relationship. That is not the same as a 17-year-old and an 18-year-old. Even if in both cases the two individuals at the time thought that's what they wanted. Right, a 17 and 18-year-old, okay, a couple of days really doesn't make that much difference. That's not a crime, at least in my mind. I suspect most of you would be in the same boat. Whereas a 30-year-old and a 14-year-old, that's a crime. There you have an adult manipulating a child. Okay, and the law is... Now, the way the law actually works, prosecutors have latitude. Your typical prosecutor doesn't prosecute a couple of teenagers who are close in age, usually. But if the underaged one has parents that get really wound up about it, then they might. If it's election time and the prosecutor, the district attorney, wants to be tough on crime, yeah, they might. Okay, to me, that would be an example of a situation where our law ought to be more precise. It ought to very clearly delineate in some ways that makes it clear that those are not the same thing. So, I mean, that would be another. Executive malpractice. This is your classic where the law enforcement agency, the police officers, whatever, the people implementing the law, botch it. They make a mess of it. Either because they're maliciously trying to subvert the law or because they just make a mistake. So this would be the cop who gets too excited and does a search without pausing to get the search warrant when it wasn't strictly necessary for safety, when there was no real justification. Okay, so a person finds then evidence of a heinous crime in an illegal search. Well, that's executive malpractice because that evidence cannot ever be used in court. Problem. The law itself can be super rigid. If you define it in rigid ways, don't give latitude to the judge or whatever, then you end up with rigid, sometimes stupid outcomes. Now, good things about this, when it's used properly, everyone is equal before the law. Doesn't matter what color you are, what age you are, how wealthy you are, how well educated, gender, all those things don't matter. Everyone is equal before the law. Okay. Only the relevant things, the actual questions of law, that matters. It's predictable. You know what the law is. You know what the standard of evidence is. You know what the potential penalties are if you break it. You know, if you're caught, these are the potential penalties. This is the process by which they'll determine whether I was guilty or not. It's predictable. We know what it is. You don't get caught with, well, you know, you offended someone. That's a problem legally. So it's good in that sense. Okay, so two basic polar opposites. Every system probably has an element of some of both. I want to think about our modern system. So here we have this particular one. You can pause and compare the two in one chart if that's useful to you. I don't need to talk through it any further than that. I want you to think about, and we would have a conversation about this if we were in class for real. Which of these two systems do you prefer? Which do you think is the better system? If you are going to be judged for some allegation that you violated the law or community standards, which would you prefer of the two? We're going to think about that, and perhaps we'll try to have a conversation when we get back. Think about the American judicial system. What does it look more like? Is it natural law or is it legal rules? So anytime a police officer arrests you, if they're going to take you to court, they have to be able to cite specific law, chapter and verse, exactly where in the law does it say. You can't do that. Okay, that makes it legal rules, right? The law is written. We try to do all those things, equality and all that in the law. It's precise, all that stuff. Where do the laws come from? From the legislature, from our Congress, and so on. Okay, so ours is mostly natural, mostly legal rules. Now that said, you're looking at the judge's job. The judge just plays referee. The judge doesn't determine guilt or innocence. The judge isn't supposed to weigh in on one side or another. The judge just oversees the process of presenting evidence. And there are rules, laws, about what evidence is and is not admissible, how it can be presented. And the judge oversees all of that. The judge is simply a referee in the process of implementing legal rules. Now, once a jury says guilty, if a jury says guilty, then our laws almost always have a fairly wide latitude of sentencing, from a fine of $500 to up to 10 years in prison, for example. Okay, so the judge takes off his legal rules hat, his umpire's hat, and puts on his King Solomon the Wise hat, and tries to then determine, okay, what are the specific circumstances? Are there extenuating circumstances? What is the best solution for this specific defendant or convict now, in this specific crime, under these specific circumstances? Is this a first-time offense with an understandable, they were, in a situation they couldn't control, kind of understandable mistake, or is this flagrant, deliberate, malicious abuse of the law? Well, what is it? And then they determine a range. So it becomes a little more natural justice at that stage. Basic idea.